update. This legislative update is brought to you by a host of folks. We got a great team that are going to be putting on this training. We have members of our policy team. Hopefully, you folks know them: Charlene, Sav, Rory, and Trish. We're also joined by Aaron Goldstein, John Greenleaf, Emily Dale, and we'll also be joined by Alexis Mansfield from the Women's Justice Institute. We are going to be covering kind of all the things, all the new laws that were passed in the 2024 spring session. I want to give a big shout out to our policy team who, goes down to Springfield, try to get laws passed, has had some real success, but also does a lot of defense as well. It kind of reminds me of a very quick story. I was a public defender in the office for a minute, and then I left, and I came back. And when I left, I did some work in Springfield, and I always wondered as a public defender why the laws kept getting worse and worse and worse and worse. And I just thought it was kind of like happenstance, and it's not. It's not happenstance. Prosecutors, police, sheriffs, they are constantly working to change the laws and make the laws worse for our clients. And it takes a real strong effort for us to kind of turn those things around. And we've seen some really strong successes for our policy team that not only does legislative work, but also all types of assistance for our staff, our attorneys. So it's not just the legislative work that they do, but they do a great job all around. So thank you all for doing the work that you all do. Thanks to all of our guests who are going to be presenting, and thanks to all of our folks from outside of our organization that are joining us, and obviously thanks to all the attorneys that are making it happen on the line. So with that said, I will kick it off with who's starting. I'm a bad point guard. I don't know I don't know who I'm passing to
I'm
first. Sharon.
starting.
All right, Sean, passing it to you. Thank you so much.
Thanks, Sharon. So we are starting out with changes to criminal law. And just a reminder today, thanks to our professional development division, that we open this training up to folks from OSAD and other public defenders from around the state. So it's not just a Cook County training today. Obviously, our practice expertise coming primarily from Cook County, but just as a heads up, we're glad to have our friends here from around the state. So the first bill that I want to talk about is actually an initiative of our office. This is one that we've already talked about in all staff meetings. Hopefully it's familiar. It does not go into effect until January 1st of 2025. And we want to flag that for every bill we're talking about today, these are bills that not only passed, but they have all been signed by the governor. So they are all laws. But the question is when they take effect. You're going to see a lot of effective dates of January 1st of next year. So we might be talking about things that are law. They've been signed by the governor, but they're not in effect yet. Doesn't mean you can't use them in your advocacy depending on the exact public act or issue. So this bill is one that our office developed and worked on with Cabrini Green Legal Aid and was supported by other partners. It changes the title of unlawful use of a weapon and related offenses to unlawful possession of a weapon to reflect the actual behavior. And the hope is that this will reduce stigma faced by our clients who might have this charge on their records when they're applying for jobs or housing or similar. Also popular media misunderstandings of what it means to be accused of what's currently a UUW. It also changes the title of armed habitual criminal to unlawful possession of a firearm by a repeat felony offender. That obviously is not a lovely name. It's not our first choice name. It's not the name of this offense that we proposed, but it does describe the actual behavior, the unlawful possession of a firearm, and not the person, the way armed habitual criminal did. And more importantly, it matches other existing statutes for gun possession in furtherance of our future work, in which we hope to address the penalties on armed habitual criminal by either repealing the statute or integrating it in some way and minimizing it as part of UUW, or what will soon be UPW felon, since we all know that is a particularly stigmatizing name and offense title. Unfortunately, this bill doesn't change the definitions of the behavior or any of the penalties. So it has some utility, primarily to people who aren't practitioners, aren't in the weeds on this. And keep that in mind, it's prospective starting January 1st of 2025. And if there are, and just also as a reminder, please ask us questions. If you have any, you can drop questions in the chat. You can just unmute yourself and talk. It will be more interesting and more useful for us. If you ask us questions throughout, don't feel like you have to save questions. Allison, great question. There was discussion of renaming armed violence, and we struggled to come up with how to rename it. It's absolutely on the table. It's another terrible offense name that really misrepresents, right, the fact that someone was just accused of possessing guns or a weapon and some kind of drugs or controlled substance at the same time. So that is absolutely something we're aware of and keeping in mind. But it wasn't something that was part of this bill. And also the other thing I want to say to add to what Sharon said, it was an election year this year, and there are a lot fewer bills in our bill summary than there were last year. So every single member of the House of Representatives was up for election this year. A third of the senators were up for election, and there was not a lot of appetite. There's still more legislative session happening later this year in November. There's going to be a brief legislative session in January of next year called lame duck. We are still hoping to pass more of the office's bills during those times, and we hope many of our advocate partners will as well. But if you are looking through the summary document and it seems like, hey, there's way less substance here, way less things to benefit our clients, you are not wrong. That's one of the impacts. But it doesn't mean it's every year, and we're always building and talking about bills, even if we weren't able to pass them, to move them forward. I'll give the floor to Trish.
No, actually, we're going to go to Emily Dio.
I have been tasked with discussing the child porn bill, so I know everybody wanted to be the person who got to talk about this. This is also a bill that Sharon, or I shouldn't say bill, this is an example of a law that is getting worse and worse, I would say, and that is really easy to get everybody on board because nobody wants to be opposed to bills that are against child porn. So basically this bill or this law does a bunch of things, and it's easy to go down a rabbit hole. I want to give sort of a high level overview of it. It expands the definition of child pornography to essentially include a provision that now says a depiction of an actual child that has been modified falls under the definition of child pornography. It also creates new offenses. One is obscene depiction of a purported child, and one is non-consensual dissemination of sexually explicit digitized depictions. So the first one, that obscene depiction of a purported child, is essentially AI-generated pornography. So this is a very hot topic. It's very much like people think that we need to panic and make a bunch of bills because people are now using AI technology to create a whole host of things, including child pornography. My review of the way this has been written is that, number one, it's extraordinarily poorly written. Number two, it's likely possibly unconstitutional, as previous laws that do not involve an actual child. So that's what this means, a purported child. It could be an actual child. It could be an entirely AI-generated image. Those provisions of statutes federally and in the Illinois child pornography statute. And Scott, I see this, yes. So provisions in the federal child pornography statute that deal with virtual or not real victims, not real children, have been deemed unconstitutional. I think then when we talk about bad law, this is something that it's a knee-jerk reaction to sort of hot button technological issues, and that people aren't questioning the applicability or the feasibility of this statute or this bill being held up in court. I don't see, based on prior case law, how entirely virtual or entirely AI child pornography images will be found to be constitutional. So in terms of our practice, what we need to be looking at, if come next year, you are seeing cases where this obscene depiction of a purported child is charged, challenge these. This is not good law. The non-consensual dissemination of sexually explicit digitized depictions, which is a real mouthful, I think we might have a harder time with, because could be an actual person whose face or is put on some type of manipulated image. That's a possibility. If there's a real person, so an identifiable victim, then courts have held that that can be considered pornography, even if the images are morphed or and you can tell that I am not technologically savvy because I don't know the correct vocabulary to use. But if there's a real person, an identifiable victim, then it doesn't necessarily matter if the entire image is real or if it's been manipulated somehow by technology. Where I see that second, this non-consensual dissemination issue, thank you, Charlotte, deepfakes, where I see this being a biggest issue is probably over at JJ. With kids who, if there are nudes that are sent back and forth, or pictures of kids at school where maybe their body, they're making deep fakes of actual classmates. I think oftentimes over here at 26th Street where I practice, we don't get that many child porn cases. If it's on a big enough level, it goes to it's a federal case. But we need to be paying attention to if there is an identifiable victim or not, because these charges, they introduce possible extended term sentencing, possible consecutive sentencing if the state charges these new offenses in addition to existing child porn laws. It would trigger registration requirements for people who are convicted of these offenses. And I also see with the obscene depiction new offense, there's a real good chance for overlap with existing child porn laws. So there might be double charging. I'm just reading Benjamin's question. Is it identifiable or identified? How would you prove a negative that an AI image is no real child? That's a question I cannot answer. I don't know. And I think that that's something to look at generally when we have child porn cases at all, right? Is it sort of, if that is an element of the case, and if it's not an identifiable victim, then there's an argument to be made here. I don't want to get too deep into the weeds here because I know we're keeping it high level. So in terms of issues for our practice with this law, number one, the biggest one is the constitutionality of at least a portion of this new law. The ability for the state to be overcharging, consecutive sentencing issues. And then again, those of you who practice in juvenile court, I would be really keeping an eye out for that non-consensual dissemination charge. I think I'm ready to pass it on, and happy to answer any questions anybody else might have at any point in time too.
Awesome. I will take it from here. Hi, everybody. Patricia Jemba on the policy team. I want to highlight clarifying non-conviction probation programs. This is a law that was an initiative of our office in coordination with the President's office. So as Charlene mentioned, this is one of the laws that takes into effect January 1st of 2025. And essentially what this law does is the clarifying piece of legislation, in that it simply clarifies that participation in certain special probation programs in which judgment is withheld should not be considered a criminal conviction. That is, while someone is participating in one of these programs, and certainly after successful completion of one of these programs. So when we talk about which specific programs we're talking about here, those are ones that are outlined in, for example, the Second Chance Probation Program, first-time weapons offense program, as well as diversionary probation sentencing programs related to controlled substances, cannabis, and methamphetamine. Another thing that this law does is also it clarifies the definition of conviction under the law. So it adds, again, some clarifying language. Specifically, in the definition of conviction, it sets out that if judgment is withheld, the plea, verdict, or finding of guilty is not a conviction under Illinois law unless and until judgment is entered. Again, hoping that this sort of clarification in the statute will ensure that, for example, prospective employers, landlords, or anyone else outside of our system that is trying to interpret what someone's status is, participating in one of these programs or having completed one of these programs, we hope that this language provides that clarification.
And I just flag really quickly for those of us in Cook who have been discussing collection of DNA from our clients on these specialty probation programs and fighting with probation about whether or not these are convictions. This is going to be another tool in those arguments, and it's something that we'll be preparing practice resources for to try to prevent collection of DNA from those clients in advance of this January 1st effective date. And Trish, I think you have some questions in the chat.
I am not able to see.
One question is about immigration law, and the question was, your question is correct, Elisa. It is when people participate in these programs, they do plead guilty. So even though court's judgment is withheld and it's not considered a conviction if they successfully complete under Illinois law, it can be considered a conviction for purposes of federal immigration law. And that is something that we're interested in changing in the future, but it has not changed, was not changed by this law. In terms of the court process stays the same. And that guilty plea would be a problem for immigration. And Christine, the question about specialty court probations or problem-solving courts, I think if they do the same thing, it would, those statutes weren't amended in the same way, but the definition of conviction would apply to everything in Cook. This wasn't something we were focused on as our problem-solving courts, I believe, are all post-conviction, and we did work with Silvana on this bill, and they are convictions while the case is pending rather than vacated at the end of the successful completion. So that's a different process than pleading to probation where judgment's withheld. Hopefully that answers that question.
I'm sorry, I can't see if there's any other questions, but please
No
let
other
me.
questions right now.
Okay. Okay, and I think I'm passing it over.
Okay, thank you. For our next presenter, we have Alexis Mansfield from the Women's Justice Institute. Hi, Alexis.
Hi. My apologies. I'm in a hotel lobby, so it's pretty loud. So I hope that everyone can hear me okay. Great. And enjoy the background music. I'm joining from the Women's Justice Institute, where I'm a senior advisor on issues related to relationship safety and children and families, and Ascend Justice, where I'm the director of the Incarcerated Survivors Program. And just to give a little background on each of those organizations, and oh, I'm so glad that you can't hear this because it's not the best music. Just to give a little background on our organizations and what we do. And how we can work together, because I see many familiar names here today that we have collaborated with. At the Women's Justice Institute, one of the main ways that we work with people who are pretrial is that we have a grant through SAMHSA to assist with substance use disorder treatment, where we can access beds at Haymarket, and we provide client care coordination for a year for people to get all kinds of services. And we even will come into court and explain the program, and have been successful in having many judges allow people to be placed in that program. We also do reclamation circles monthly, led by and for impacted women to come to be with others, to express what they're going through and to get support and planning for the future. We have specialists who then help people make those plans. And we have an emergency fund that people can access if they are currently pretrial or post-conviction, or their immediate family members for those emergency needs. And we also have a bus program that goes down to prison and brings kids to see their moms every month. And then at Ascend Justice, we help survivors of domestic violence, trafficking, sexual violence, stalking, that type of thing, with things like mitigation letters, particularly related to domestic violence, children, or immigration issues. We assist with orders of protection while people are at Cook County Jail. And we do mainly family law for women around the state who are in jail or prison, and some post-conviction assistance. And we have worked with a couple of public defenders recently to provide expert assistance regarding pregnancy for people who are pretrial. So that's just a little background, because these are the two bills, laws now, that we worked on this past year, these two public acts. The first is the rights of pregnant prisoners. And it does a couple of things. One of the main issues is that restraints have been banned for people who are pregnant, but only in Cook County in the state. It is banned statewide currently for people who are in labor anywhere. But in 2012, the statute changed to ban restraints during pregnancy in general, but said only for counties of a population of 500,000 or more. Again, pregnancy is the same no matter what county you are in. It doesn't matter the size of the population. So this expands it to restraints being prohibited except in extreme cases statewide. It also extends the postpartum period, where people could be restrained after postpartum period statewide. Before, postpartum was defined for all counties as the time that someone spends in the hospital after delivery. So in most cases, that was 72 hours. This now extends it to 6 weeks. It also requires additional calories for people who are pregnant or who are lactating. That's 300 calories required per day while in custody. So that's a supplemental, and not to be given during normal meal times, or if it is, to be made available outside of meal times to prevent gastro issues. The big thing that I think people on this call might be interested in is that it also limits the use of electronic monitoring for people who are pregnant and requires the removal during labor or delivery. And we always have to clarify it, labor and delivery, because some counties previously would say that C-section and planned inductions were not actually labor and that they could restrain during those times. And so that's why that language is in there. If a doctor says that it is medically necessary or even indicated that the device be removed, it is supposed to be removed. How that will actually play out, we are not entirely sure yet. But it has been happening in Cook County, and so far has gone fairly well. Another thing is that it does require the posting of rights for people who are pregnant in custody, including things like you can't be in a bed more than 3 feet off the ground. You're supposed to have the right to certain things, including what the procedure is to obtain an abortion or to obtain information about guardianship or adoption if somebody wishes to have that. And that is the main pushback we received on this. It was largely an agreed initiative. The Sheriff's Association did agree to this, but we did have some people who opposed it because it did require that people who wish to obtain an abortion could get information on how to do so. Any questions about that? Okay. And I'll say if anybody needs additional information about that, we did release a report to the Women's Justice Institute and the ACLU earlier this year called Expecting Justice, which is helpful if you're preparing a motion for somebody who is still being detained, who's pregnant. Thank you, Charlene. That you can use that report for information if needed. And then the second public act is the Gender-Based Violence Resentencing Act. And I'm excited about this. This is, I think, the third time that we've talked about this, the third time that we've had to change it. So this is in response to the Supreme Court decision in November of 2023, in People v. Wells, where they said that plea deals were not eligible for resentencing under 214.01 Section B5, which is the Domestic Violence Resentencing Act, which is now the Gender-Based Violence Resentencing Act. And so what the Supreme Court said in that decision was basically that if the legislative intent had been to include plea deals, that it would have said that explicitly, not just in the discussion, legislative discussion, and not just saying all convictions. And so we did exactly what they said. It now says and plea deals. It undoes the sentence. It does not undo the conviction. The State's Attorney Association and the Attorney General were not in complete support of this, I have to say, and I expect pushback in some counties and for them to be appealing these cases because they really think that they have a receptive ear in the Supreme Court to maybe try to undo this. And we have many discussions about that. However, we've already had some Cook County state's attorneys withdraw motions to dismiss on cases that were filed for people who had taken pleas based on the fact that this has passed and been signed. So we're hoping to at least get a few through and to see what the Supreme Court does, since this followed exactly what they asked for. Any questions? Thank you.
Hey y'all, I'm Sav. I'm with the Public Defender's Office, and I'm going to be talking about two bills that impact young adults. The first is a bill that was led by the Illinois Department of Juvenile Justice over the past 5 to 10 years, as the average age has increased of young people at IDJJ. They've expanded their work to focus on young adults and employment. They have a program at St. Charles that focuses on young adults in their IDJJ facilities. With their transformation project, there's been a lot of push from advocates to close facilities that aren't impacted by that transformation. One of those facilities is Harrisburg. And IDJJ, in conversations with IDOC, started planning a project to use Harrisburg to sort of replicate what they'd done at St. Charles in terms of the employment programming for young adults at Harrisburg, and attempt to transfer young adults from IDOC facilities to IDJJ facilities. So this bill was IDJJ's way of putting that into law, that they could do that. So it has an effective date of January 1st, but they've been in conversations with IDOC for a while now. So I think they're in the lead up to launch the program at Harrisburg, probably in pretty early next year. Next slide. All right. The second bill, the reset bill, was initiative of our office, the State's Attorney's Office, and the Cook County Justice Advisory Council. In Cook County, there's been a pretty massive expansion of deferred prosecution programs and other specialty courts. Over the past few years, folks have really tried to expand the use of expungement of cases in those programs by ensuring that expungements can happen at graduation. And there was a real effort to implement that, but unfortunately the chief judge here in Cook County issued a memo about their reading of the statute that expungement could not be pre-filed for. So we did a lot of work here in Cook to address that, but it seemed the only way to do it was really legislatively. So this bill was an effort to make clear in the law that for these programs, folks can pre-file for expungement. And this bill states that folks can pre-file for expungement up to 61 days in advance of their successful completion of these programs. So this will allow folks to have their attorneys pre-file these expungements and at their graduation have their case expunged. And that is all I have. I don't see any questions in the chat, so I'm going to hand it off to Rory.
Thank you, Seb. I'm Rory McHale from the policy team, and I will keep us moving here by closing out our criminal legislation with two quick changes to specific statutes. The first is for stalking. So if you have these stalking cases, I'm sure electronic monitoring has already been part of how that is developed in our modern world. This is explicitly codified and amended the statute to include those electronic tracking systems, whether it's GPS monitoring. There are all kinds of different apps, as you know, that can do this as well. So even though that's been part of the stalking prosecution so far, this includes it specifically as examples of that course of conduct that prosecutors need to show. And the second specific change is to our hazing law for all of your hazing cases, right? But this is a type of charge we can see stem when these do get into very serious allegations or serious harm, often in the higher or lower educational setting. And the most obvious defense to a hazing charge is the consent of the person involved, that this was not a criminal or aggressive act. There was full consent here, but this is now explicitly a part of the law to take away that major and perhaps most obvious defense. Consent cannot be used to argue against this charge. So it's something to keep in mind, and sometimes you'll see this as a piece added on to other allegations. And with that, we close out our adult criminal legislation, and I will pass it to talk about another change to our traffic systems to Mr. John Greenlease.
Hello, everybody. My name is John Greenlease. I'm an attorney supervisor with the office. I'm currently in the Skokie 2nd District Municipal Building. The statute I'm going to talk about is the elimination, basically, of the failure to appear suspension. So for those of you who know how to read an abstract or have helped us out at the Driver's License Expo or have been to one of our many things on it, that is the 09 suspension. That's a suspension that the judge on a petty case could issue if you failed to appear in court after a 30-day notice. This was under the old statute. The problem with this statute was that it wasn't so much the statute, it was the procedure. In order to get that suspension off your license, you had to go into court, get the case back up on the call, deal with the case, plead to it, whatever you're going to do, and then the Secretary of State would be notified you had done that, and that would then lift your suspension. But you had to do all those things. And at least in Cook County, that could be a 2 or 3 day process. And I mean by that, days off of work. In some of the districts, you could go in and get the case up that day, pay your $40, get it taken care of. In most of the other districts, you couldn't do that. You'd have to go pay your $40, and then they would tell you, either you would go to court, and the judge would say, oh, okay, this is a so-and-so jurisdiction case. You have to come back next week or in a month or in 3 weeks or whatever it is. And we had many people, obviously, many clients couldn't take that many, thought they were going to take care of their problem and then couldn't take care of their problem, and they couldn't take more time off of work. And so they remained suspended, got caught driving, and that's how they became our clients, because the statute only applies to petties. But the reason it affects all of us is because this is a very, very popular basis for having your driver's license suspended. And as I just said, it was not an easy thing to get undone. So what this bill does is it has eliminated the failure to appear suspension basis. That particular option that the court would have if you did not appear for your petty ticket. The court always had other options. But this takes away this, what was called an FTA or an 09 suspension option. The statute that provides after the 30 days notice, if you fail to appear on your initial court date, that what can happen now is what was always available before is an ex parte conviction. And then it sets a cap on the fines and the court costs, basically citing to the statute or to the schedules for each, whatever the offense is. And they then notify the Secretary of State. So that is still going to have an effect on people in this way. That will not suspend your driver's license, but if you don't pay that, it will keep you from being renewed, updating your license, getting it, when it expires, getting a new license, moving to another state, you will need to pay that. And I suppose arguably, if somebody wants to be, some judge or a prosecutor wants to be obnoxious about it, since it's now an ex parte conviction, they could, I suppose you could argue, if this is more than 2 years old, you're outside the 21401, tough luck, this is on your record. And I suppose that is the other thing that is negative, if you will, for individuals who have this happen to them. It is points on your license. If it's a third conviction, it could cause some other suspension. It is vacatable though, but the procedures are would be a little vaguer on that. You could still go into court, say, hey, I didn't mean to not appear. Please give me supervision, do whatever we're going to do. The other thing is that it goes back till January 2020, and it eliminates all the 09s that were issued from January 2020 till the, I guess, the effective date, which is January 2025, because they're going to continue to do this, I assume, for the rest of the year. That's helpful. There are still a lot. It'd be nice if this would have lived. This, by the way, people who've helped out the Driver's License Expo, and if anybody doesn't know what that is, our office sponsors, and for many years has sponsored with Pilsen Neighbors, the Circuit Court, and the Clerk's Office, some other partners, something called the Driver's License Expo, where we help people clear their driver's licenses, clear their suspensions. One of the things that we do most often is we have court. It's on a Saturday. Circuit Court provides judges, the clerks provide clerks, and we clear 30, 40, 50, 60 of these 09s for people. So it would be nice to say we aren't going to have to do that anymore, but obviously there's a ton of them issued before 2020. This was very popular in misdemeanor cases. I think you could probably go in and get the order vacated based on this new statute now without a problem. I don't think any court will give you a hard time if you come in and say, hey, I have an old 09, please vacate it. That is about it. As I said, the January 2025 is the effective date.
And John, you just had one question in the chat there. How are courts going to be keeping track of this?
So they have always notified. There's always been a procedure on these FTAs. There's specific forms that the Secretary of State provides to the clerks across the state. And this statute provides that the Secretary of State's going to have to make a form for this, that the clerks are going to have. So the clerks are going to notify, just like they did on the 09 suspensions. Hey, this guy didn't show up on the 30-day continuance, suspend him. They're going to notify, hey, we just ex parte convicted this guy, and he owes us this much money. That goes on to your abstract. It doesn't suspend you, but it's notated on your abstract so that when you go to renew, they say, oh, you seem to owe Cook County money. Here's the information. Go pay them and come back, and we'll give you your driver's license. I think that answers the question. They're gonna, and as far as the suspensions go, right now, as to the 2020s, those are just coming off people's records. They don't need to do anything. In fact, for this expo, we're still going to do these people. After January, we're going to have a whole bunch of people who sign up for the expo to get their license suspended. They're not going to know they're not suspended if that was the only thing suspending them. When they lifted the parking ticket suspension on everyone, we went for 2-3 years. In fact, we still occasionally see people who come and tell us, oh, my license is suspended because I got all these parking tickets. I don't know what to do. And we say, no, it's not anymore. Please go get your driver's license. But they don't really tell that many people. So you would really need to know you had an 09 and this was out there. They're not going to go tell people that this has come off. It's really more for our purposes. So anybody else? Oh. There you go. Yes. I just added, this was something that was part of, I think I should call it the transit table, right? Group of people who eliminated the parking ticket suspensions, as Charlotte just pointed out to everybody, or maybe just to me. And we are working on other things as well. eliminating some of these other things. So this is a really good thing. It'll help some people, and then it'll help us, I think, help more people. Anybody else? All right.
Thank you. And as we've noted in the chat a little bit, we're not going over every bill that touched our practice today, just highlighting a few of them. So we have released a couple of versions of our legislative summary there. You can read more about regulation of electric scooters, of the upcoming digital driver's licenses, and of catalytic converter resale changes. But for now, I will pass the microphone to our great pal, Aaron Goldstein, to talk about some of the changes in the family defense space. And Aaron, just let me know when to change slides.
Perfect. Thank you. Good to see you all. Sorry, I'm a bit in the shadows. I'm in the wonderful just location of the juvenile court building complex. So a lot of bills have been passed, but in the Illinois legislature's never-ending battle to make this wretched system just a tiny bit less wretched, instead of actually making it fair and just, we have the 2024 spring legislative session update. All right, so with that, the first bill you have before you is regarding drug-exposed infants. It seems like there's a process to eventually get rid of the drug-exposed infant statute that is the basis for a neglect finding. That has not been done here. What this has done is it changed a rebuttable presumption. It eliminated for ground K of the Adoption Act a basis for unfitness. It changed the rebuttable presumption. It also eliminated ground T. Those that practice in this world and done TPR trials, for the most part, grounds K and T really aren't utilized that often, but nonetheless, T is gone, K is hurt a little bit, gets rid of that presumption. So we think this is a move in the direction to eventually get rid of drug-exposed infant statute. Hopefully that happens soon enough. You go to the next slide. So these are two bills, not super impactful to our clients, but nonetheless has some connection to our work. This DCFS scholarships expands scholarships for youth in care and youth in the system. Begs the question, why don't they give the money to the parents? But I digress, that's a political issue. Nonetheless, what it allows is for these scholarships to be expanded so that if a student who's a youth in care or a ward is sort of at least going along with their studies, they're still eligible for these scholarships. The Abandoned Infant Newborn Protection Act basically says there's a situation, an exception where an individual, a parent, leaves a child, an infant, a newborn at a hospital, and they come back within 30 days of leaving that child at the hospital. The law requires that notice be given to the parent to say, here's the information in terms of the DCFS, agency that has the child. So they're provided notice to if they potentially reconsidered their sort of abandonment of this infant. No, good timing. We did good, Rory. You could go on the next one. Parental liability for DCFS services. DCFS, the wonderful $2+ billion agency that says, hey, let's take your kids and ask for more money from the parent. They've modified that. So for the most part, parents are not monetarily liable for the cost and care provided by DCFS. There are some exceptions. One of the exceptions now through this bill is if the goal has changed. So they can refer case. What this bill does is says DCFS will not refer cases to child support enforcement, i.e. the state's attorney, to go after a parent for child support. But it does allow them to go after them if the goal has changed from return home to adoption. For the most part, we don't see this a whole lot. There's waves every once in a while that it happens where DCFS says, hey, we want to try and get some money from parents. That's somewhat of a dead practice, but this codifies the growing move towards not doing this at all. You can go to the next slide. The hair care plan for youth. In care, I call this the take the child, care for the hair bill. I think it really, really loses the point, which is maybe we should keep children with their parents so the parent can maintain their hairstyle in a culturally sensitive and informed way. But instead, we have situations, and unfortunately, it's a terrible experience for parents and children who typically, when they are removed from the home, if they are removed and placed in a foster home, that's a different race or culture or religion than from where they came. Many cultural practices are lost. One of them being hair care. And many people know how important hair care is to a lot of people, a lot of cultures. So this is trying to sort of rectify that. I will know that what basically is supposed to happen is there's supposed to be a hair care plan. So they're supposed to look at this from a culturally sensitive, racially sensitive, religiously sensitive aspect and view. However, there is a pretty broad exception, which basically says that the parents are to be included, which you would think is the most important part of this, unless, quote, if not contrary to the youth's wishes. So it really empowers youth. I would think a little bit too much, because it basically says a youth can say, you know what, I want to do my hair a certain way, when the parent may know from passed along from generation to generation to say, hey, this is how we care for the hair. Youth influenced by a foster parent at a young age can say, no, I just want to do my hair the way I want to do it. So there's a certain cultural sensitivity to this bill, but there's also a missing the greater point, in my humble opinion. You could go to the next slide. Okay, parental liability for DCFS services. This really doesn't impact us a whole lot, really much at all. It basically adds the word adult to when children are adopted, and it basically codifies what we've already known, which is once a child is adopted, that parent's rights are terminated and obligations as well. It just includes the word adult, which is defined as 18 or over. I think we have one more slide that we could go to. This is child abuse reports to school. Basically, it narrows, it doesn't narrow, it sort of rounds out exactly what needs to happen in terms of a report that needs to be sent to school. So DCFS would do an investigation of a student that the school reported, and they would sometimes informally get back to the school. This codifies to say a final report needs to be sent to them if an allegation of abuse or neglect were made, so the students or so the school becomes informed of that. Again, not really impactful to our work, but nonetheless a variation of the law that currently stands. I think that's all we got.
Thank you very much, Aaron. And it was a tough year in Springfield for bills, good, bad, and ugly, to pass. And in few areas was it tougher than in youth defense or juvenile justice. But to talk about a pair that did come through, I will pass the mic back to Charlene.
Great, thank you. So the first bill we're talking about was an amendment to the automatic juvenile expungement laws. And what it does is direct the court to schedule a date to enter the automatic expungement order. So folks in JJ spaces probably know we have automatic juvenile expungement, but in reality, I believe it was up to our attorneys to affirmatively go in and motion those cases up and make sure there's a court date set for that expungement to take place. So this was an initiative of the governor's office to clarify the process that courts should be following, and to say at the time when a young person's sentence is over, or if they're committed to DJJJ, basically, I think I just said 3 J's, DJJ, basically the last time that case is in front of the court should set a date to enter that automatic expungement. That's the best time when they'll have the most information about that young person's future eligibility for automatic expungement. And if when that date comes, the young person will be notified, but they're not required to be there. If the young person is eligible, they will be, the expungement order will be entered. If they're not yet eligible, but will become eligible in the future, the court is instructed to set another date in the future. So The next one is another really simple one. Thank you, Rory. Heavy is the head that has to move the slides. So the next one is juvenile records expungement for trafficking victims. So if a young person is a victim of human trafficking, they have, I guess, extra eligibility or earlier eligibility to expunge those records that are already expungible under the Juvenile Court Act. So that's all for juvenile defense. You all know, if you have come to the all staff meetings for our office or other meetings like the policy focus group for youth defense, we have a lot of bills. A lot of our friends and advocacy organizations have a lot of bills that will really be much more material in the way cases move through the court, not just for relief after the fact. So hopefully we will have more of those updates in the future. And I will pass it to Trish, who's gonna start our quick overview of related issues.
Thank you. Yes, very, very quick. Crime victim DNA, this is Public Act 1030792. This is another one that takes into effect January 1st of 2025, and it simply amends the Rights of Crime Victims and Witnesses Act in that it prevents crime victims' DNA from being entered in any DNA database. And that's subject to certain exceptions. Moving on to study of discriminatory sentencing. This actually already took effect last month in July of this year, and this would instruct the Illinois Sentencing Policy Advisory Council, or SPAC, to both study and identify discriminatory practices in sentencing throughout the state. And then from there, make recommendations to the governor as well as to the General Assembly in terms of ways to remedy those discriminatory practices. Next slide. Two more here, the Illinois state IDs for people leaving federal and county facilities. This took into effect earlier this month on August 6th, and it amends the Illinois Identification Card Act to add federal and county facilities to a list of places that incarcerated people can receive state IDs. So previously that only applied to individuals leaving IDOC as well as IDJJ. And it establishes new procedures in terms of how to issue those state issue IDs. And then is there a definition of discriminatory sentencing in the statute? I think so.
I can pull the text up and drop it while you keep going if you want, Trish.
No, thank you. I just read the text earlier, so I didn't want to misspeak. So thank you. Or misremember. The final one here on this slide, police training for autism informed responses, which I think is going to be extremely helpful to a number of our clients and just people in general throughout the state of Illinois. This is something that's going to take into effect January 1st of next year, and it essentially requires law enforcement as well as correctional officers to go through specific training related to autism informed responses, as well as being trained and caught up to speed on best practices and techniques on how to engage with individuals who experience autism. And we will get an answer to that question about the definition. I'm going to pass it over to Rory to wrap us up so that we keep moving.
Okay, and I see there's one question there about, is the goal of the discriminatory sentencing study to address justice by geography? So often we will find bills like this that pass without a full recitation of the goal, but as Charlene cited there in the post, in the statute, sometimes there's a listed preamble that can help justify or bolster the purpose of task forces or these other committees. I
would add, Rory, on this one, you could, if either of you remember, I believe that this was an initiative of Senator Lightford, and I think it could be geography based, but I think it might just be fundamentally like racial discrimination within sentencing. That's my recollection of the discussion about it. Rory and Trish, is that right?
That's
that
right.
jives with my recollection too.
All right, and now we will land this plane here, folks, with a couple of other bills that just touch on our practice as well. Another task force that's been created here, the Community-Based Corrections Task Force, to get a wide variety of what they'd call criminal justice stakeholders together to talk about establishing, developing innovative ways to introduce community-based corrections and rehabilitation. That some people say that sounds like the probation system we already have, but we are working carefully to get public defender representation on these committees, because they're often the bodies that release a report that becomes the basis for legislation going forward. That's going to begin meeting in the new year. Next, we have domestic violence remedies here. So we know that our clients in the office are often some of the individuals that have suffered and gone through domestic violence as victims themselves. This is just a touch point you can explore further, or reach out if you have more questions about that talks about some of the additional rights you can have in housing, in other arenas of law. If there is, established record of domestic violence that can be used with landlords, and a requirement on landlords to provide that information to all tenants. The last two are somewhat specific changes in collateral consequences and crime victim compensation. So crime victim compensation is often something that's been used to go after individuals either in fines and fees or civilly, individuals that we might represent in criminal courts. This is a slight expansion of the concept of that, because the Crime Victims Compensation Act now includes and expands to individuals that have been harmed or killed by law enforcement, including for psychological treatment from that front, as well as to, in the past, unfortunately, there has been a prohibition on giving those funds to individuals that are incarcerated in a correctional institute. That remains, but has been chipped at a little bit in the armor here, because you can see that criminal history alone is not a bar to prevent someone from receiving those victim funds. The actual incarceration does remain a bar at the moment. Finally, here on the great work some of our colleagues here on this call were involved in a couple of years ago around the Pretrial Fairness Act. This is the creation of the Independent Office of Statewide Pretrial Services. So it's a technical change. The office has previously been sourced within the Administrative Office of Illinois Courts. It's going to go into effect this coming year to be separately housed within the judicial branch as a standalone agency, and standalone meaning more independence there.
And just a note that Alexa's put in the chat, people can apply for victim compensation while incarcerated. They just can't receive it until released. So thank you, Alexis.
And thank you all for being here. As we wrap up, I would just note the final bill on here, the Language, Equity, and Access Act. Again, you can check out more. This was sponsored by the Pan-Asian Voter Empowerment Coalition to require the state to take intentional steps, both the Office of the Governor as well as the individualized state agencies, to have policies and practices in effect that have creation of language access plans to make sure we know the individuals we represent speak many different languages as we come into contact with them and often are in need of other governmental services. This could be a good bridge of establishing a legal basis to help out in court in getting those services. So we appreciate you all being here. We do have a few policy focus groups that meet about monthly. We have one devoted solely to fitness that's starting up tomorrow. One's for family defense and for youth defense in the near future. Please check out our email addresses in the next slide here, and don't hesitate to reach out. We'd love to have voices from across the office joining us there. This is the email address for the full powerful policy team: Charlene, Sav, myself, and Patricia. There's a general PD policy email there as well. We'll make sure these slides are available, and the emails of our great guests here, Alexis Mansfield, Aaron Goldstein, John Greenlees, and Emily Dio. Thank you all very much for chipping in today.
Thank you.